Hello. Welcome to everybody. For many of you, this has been a very long day. So it's fantastic to see so many of you here. Those of you who are here, most of those who are here, although everybody knows that I'm Manuel Leisner and I'm director of the Institute. It's a real honor and pleasure today to open this year's series of public events. The goal of this series is to engage with experts, to engage with students, and to engage with the wider public, both locally and internationally, in a continued and research-based debate about core issues relating to crime, justice, punishment, and so on. Whenever possible, the events will be hybrid. So we have, as you can see, we have a number of participants who joined online. I was just going to say that participants online will be able to post questions online, but that's not true today. It will be true next week when we organize this as a webinar. But those who are online will be able to unmute themselves and say something. Please don't say anything while the speakers are speaking. We will be having the talks for about 45 minutes. In many of the talks, we will have a main speaker and a commentator. Then we have about 45 minutes for questions, and that's then followed by further conversations outside the seminar room. For those of you who are fortunate enough to be here in person rather than joining online, those online will be excluded from this part of the event. I'm really grateful to Barak Ariel, who's here, for having put together an exciting program for this year. Many of you have already seen the program, but at the end of this event, I will briefly go through the program again, for those of you who are not MPhil students and haven't seen it yet. So it's a great pleasure to have you all here. I now hand over to Barak to introduce these things. Thank you.
Thank you very much. I'll be brief. I'm just going to present the presenters and a few housekeeping rules before I start. For those who don't know, the fire exits are on my right. See us running, but follow us. Today we have a packed event, so watch closely to make sure that once you're done, you take it. And then I can present the presenters, so dear friends of ours. Professor Catherine Campbell from the University of Ottawa. She's also our academic visitor, so she's around in case you want. She's heavily involved in studying miscarriages of justice, wrongful convictions. She examined schemes of exoneration and compensation for the wrongly convicted, as well as the study of admissibility of problematic evidence. Very interesting areas. She's also the director of Innocence Ottawa. It's a pro bono student-run innocence project that helps the wrongly convicted apply for conviction review to the Minister of Justice. We also have Dr. Anat Horowitz from Israel. She's a senior lecturer at the Hebrew University Faculty of Law, and she's academic director of the Criminal Law Clinic. She was also the Deputy Chief Public Defender for Israel, 2012-2022, where she coordinated the work of the office in the field of wrongful convictions. Dr. Horowitz brings in the practitioner's voice, as well as a systematic perspective of a jurist at the Faculty of Law. This event was born out of this big project that we've had in the past 3 years. It took us many years to gather about 18, I believe, publications, or even more than that. Very comprehensive book on wrongful convictions, so I encourage you all to buy it or to look at this book at the library. But we're also going to have some comments from our very own forensic psychiatrist, Dr. Adrian Grounds, from the Institute of Criminology. He looks at the need of mentally disordered prisoners, was responsible for providing an NHS forensic psychiatry service in Cambridgeshire, and is very much involved in wrongful convictions, Specifically, he's looking at the psychological consequences of wrongful imprisonment, which is a very hot topic for today. So without further ado, ask you to join us and share with us your thoughts about this topic.
So thank you very much, to Professor Eisner, to Professor Barak Ariel, and to the Institute of Criminology for inviting me to take part in this event. The date of the event actually is particularly significant, as at the beginning of the week, innocence groups and organizations throughout the world marked the 9th annual Wrongful Conviction Day, with the various events that took place in different countries and various jurisdictions in which they raise awareness of the causes and remedies of wrongful convictions and recognize the tremendous costs of wrongful convictions to innocents, to their families, and to society at large. So we couldn't have picked a better date to have this event, and both Catherine and I are very grateful for this taking place. I was always troubled by the phenomenon of wrongful convictions, starting with my early days as a criminal defense attorney. Certainly, since I began my work at the Public Defender's Office and was requested, as Barak mentioned, to coordinate the work of the office in respect of wrongful convictions. I recently stepped down from my position as public defender, but I'm currently still representing 2 convicts that are claiming their innocence. And I will also, in the next academic year, replace Barak as the academic director of the Innocence Clinic, a position that Barak held in the past. So the topics we'll discuss today are issues that I'm extremely passionate about, which is certainly an asset as a practitioner, but can sometimes be a liability as an academic. So I hope I will not err in this respect. So in light of this general background, and these are the issues that you see on the side that I will want to address throughout this very concise presentation, I would like to begin with describing a case that was handled several years ago by the Public Defense Office, which reflects, I believe, this case, many of the difficulties and legal problems that exist in the field of wrongful convictions. So, because of lack of time, I will very briefly highlight the details of the case, and then later on, elaborate more on some of the issues that I believe this case can highlight and demonstrate. So, as most tales, unfortunately, concerning wrongful convictions go, this is not a story with a happy end. It's the story of Ovadia Shalom, Mr. Shalom, who was incarcerated in 1995 for a murder that he consistently denied to have committed. At the Public Defender's Office, we believe that he was telling us the truth, and at the very least, when we examined the evidence, we came to the conclusion that there was no solid evidentiary basis for his conviction. Nonetheless, all our legal attempts to release him have so far failed, and in poor health and diminished spirits, he remains incarcerated for the past 27 years. Now, I believe that it's important to tell the tale of Mr. Shalom and others in this situation, not only because of his personal anguish, but because it actually demonstrates the failings of the legal system, both in terms of what led to his conviction and in respect of the barriers that exist for him to be exonerated. So what is in fact the story? What led to his arrest and eventual conviction for murder? On August 2nd, 1994, Advocate Shmuel Levinson, who was a very well-known and highly respected lawyer in Jerusalem, came home after a long day at work. He lived in an affluent neighborhood, and surprised the burglar who had just broken into his home. Following a brief physical confrontation, the burglar shot Levinson and fled from the scene of the crime. Levinson managed to call the police, but later collapsed in front of his home and died of his wounds on the way to hospital. Because of the prominence of the victim, who is very well known not only in Jerusalem, but also nationally in the nature of the crime, the murder hit the headlines for many weeks, and the tragic event and the ongoing investigation were being reported upon on a nearly daily basis. Now, this is an important point to note for two reasons. First, because many details pertaining to the crime and to the investigation were in the public knowledge, were leaked out to the public. And second, because the publicity led to immense pressure being placed upon the police to solve the crime and bring the perpetrator to trial. So as houses in the particular neighborhood were known to be popular targets for petty burglars who usually, in order to sustain drug addictions, the police rounded out the usual, the people known to the system that operated in the area. And amongst these unfortunate individuals was Mr. Shalom. During the course of several long weeks of daily interviews, Mr. Shalom gave the police officers many contradicting statements as to where he was on the day of the murder. As he would later testified in court, he was continuously trying to find a way to be released from custody in order to ease his withdrawal system. He was a drug addict, and he tried to say all sorts of things to the police to get him out. And amongst other things, he finally claimed that he was at the scene of the crime together with a partner. The partner shot the victim, and if the police will let him out, he'll show them where the gun was, the pistol that the partner used in the course of the burglary. And without understanding what had happened, he implicated himself in the murder. And based on this statement, no weapon was found. He did not know how to describe where it was, but nonetheless, he was eventually indicted. And in his petition for retrial, retrial is the legal apparatus for a claim wrongful conviction in Israel. It was later uncovered that throughout the entire investigation, Mr. Shalom was suffering from severe withdrawal systems, and occasionally that drugs were being smuggled into his cell. So this was it perpetuated the situation. He did not at any stage overcome these symptoms. Now, 7, the District Court of Jerusalem convicted Mr. Shalom of murder. And here you see him at trial, where he writes on his hand, "I'm innocent." And he was convicted by a majority vote of 2 out of the panel's 3 judges. And a side remark, I can say that if he was tried before a jury, he would probably be acquitted, because there was a minority opinion in this case. But under Israeli law, a majority of judges is enough for conviction. He was sentenced to life, and an appeal on his behalf was denied. Sometime in 2005, he applied to the Public Defender's Office, that's before my time there, requesting the retrial department to review his case and to examine the possibility to file a petition on behalf. And thus began an ordeal that went on for at least 7 years, in which the Public Defender's Office tried to retrieve all the evidence that was related to the case, and to see if there were any tests that it could run on any of the physical evidence. The main object that was the center of controversy was a mask left by the burglar at the scene of the crime. It was actually a nylon stocking, but it served as a mask. And the Public Defender's Office was keen on performing DNA tests on the mask to see if indeed it was Mr. Shalom at the scene of the crime. However, the problem was that the prosecution refused the public defender request to run tests, evoking the finality of judgment principle and the need to protect the peace of mind and emotional well-being of victims of crime, that it would cause an upheaval within the family of Advocate Levinson. The Public Defender's Office filed a motion in the Supreme Court to allow the mask to be tested, and much to her surprise, the widow of the deceased read in the morning newspaper that this motion has been filed and that the prosecution is arguing on her behalf that the no tests should be allowed. It transpired, however, that no one consulted her, and that she actually thought that if there's any doubt regarding the identity of her husband's murderer, she's the first person who wants to know. So she had to quickly retain a lawyer who wrote a very angry letter to the prosecution. The prosecution withdrew their objection and grudgingly allowed the tests to be run. However, at this point, the nylon stocking was lost. They couldn't find it anymore, and the prosecution was compelled to admit that it does not know where the stocking is, and the tests were not run. So eventually, 12 years after Mr. Shalom approached the Public Defender's Office, a petition was submitted to the Supreme Court based on fresh evidence that was not part of the original trial record, including the lack of Mr. Shalom's DNA on items collected from the scene of the crime. But, you know, in this case, you could always argue that it's by chance that his DNA is not on these specific items. Profiles of unknown individuals that were found on some of the items, medical reports supporting his claim to have been suffering from withdrawal systems, and an extensive media research. Remember, I mentioned before the fact that many of the facts of the case were linked to the press, including the investigation, and these facts that were claimed to have only been known to the perpetrator and served to convict Shalom, it was demonstrated through our media research that they were all in the public domain when he was under interrogation. So these weren't concealed facts that only the person at the scene of the crime could have known. Much to our disappointment, however, in September 2017, Mr. Shalom's request for trial was denied on the grounds that the evidence included in the petition did not meet the threshold required for retrial. So what can be learned from Mr. Shalom's case? And what can we, and are these issues that are particular to Israel, or are these worldwide problems that we have to be concerned with? Let me begin by saying a few words first and foremost about the Israeli legal system, and then I'll go on to discuss the more broader issues. So under Israeli law, I mentioned before retrial. Retrial is the way claims of wrongful convictions can be raised by convicts. It was introduced in the Courts Act in 1957. And the act dictated that these decisions must be made by a Supreme Court justice after receiving the response of the Attorney General, and since 2004, it's the state prosecutor. So we have the petitioner on one hand, the wrongfully convicted, and on the other hand, the prosecution. It's an adversarial battle, once again in court, over the question whether the wrongful conviction, whether the conviction should be open, the case should be reopened, and a trial should be held. Now, there are four grounds that you see here on the slide that one of them must be proved in order to succeed in such a petition. And if the convict is successful, the court can either immediately acquit the petitioner or refer the case to the district court, which will retry the convict based on the evidence presented by the parties. Now, in the 74 years since the establishment of the State of Israel, the Supreme Court issued an order for retrial in only 35 cases. And of these 35 cases, 26 alone ended with a full acquittal. which means that according to these figures, wrongful conviction in Israel occur approximately once in just under 3 years. Now, I won't burden you with additional data, but if you allow for the size of the population and compared to other countries, the number of cases declared by wrongful convictions as wrongful convictions by the Israeli Supreme Court is at the very least disturbing. Now, how can I validate this statement aside from to compare it to other jurisdictions? What is the actual rate of wrongful convictions in Israel or in other countries? It's very hard to know because we only know the cases in which wrongful convictions have been declared as such. We don't know what are the dark figures. It slightly reminds us of crime rates. You know, we know the rate of reported crime. We don't know how much crime takes place in general. In the literature, there have been attempts to quantify the number of wrongful convictions, and the estimates run between 1% to 5% of all criminal cases. And of course, if that's the case, then the situation in Israel is indeed extremely problematic. One can also argue that the numbers change from jurisdiction to jurisdiction, that some jurisdictions are better in fact finding than other jurisdictions. And this is a very popular claim in Israel because we don't have the jury, we only have professional judges. And so when this issue comes up in seminars in which judges attend, they always say, oh, the wrongful convictions is a problem of the jury system. We get it right because we're professional judges. And this is a thing that I seriously, I'm very doubtful about, but I will not open it up just now. And moreover, when one examines the main causes for wrongful convictions, it is clear that they're by and large universal and part and parcel of common human frailties and limitations and global issues pertaining to societies and enforcement agencies. And this brings me to make perhaps the next issue, and it's the issue of what were the causes for what are the causes in specific case, and what we can learn in general about causes for wrongful convictions, and are they indeed universal by nature. In general, case studies for wrongful convictions are extremely a useful resource for learning about causes that led to convictions, and they can also help us detect problematic practices in police investigation and fact-finding processes. Some researchers compare wrongful convictions to aviation accidents, and they claim that just as investigating plane crashes is widely regarded as an essential and basic practice in order to prevent further plane accidents from occurring, so it's crucial to study the reasons behind each and every wrongful conviction in order to reduce the rate of their occurrence. Indeed, in the past 3 decades, there have been scores of studies analyzing instances of wrongful conviction, and much has been learned through this research about the causes for wrongful convictions. One of the main resources in this respect is a registry that exists in the United States. It's called the National Registry of Exonerations. It's a joint project of several American universities. And it records, as of this morning when I checked, 3,253 exonerations since 1989. And it says on the first page that these exonerations reflect more than 28,150 years lost. Now, the registry, which has all this data, enables to detect common factors and themes regarding the cases, including contributing factors to wrongful convictions. And this is the slide that exists in this extremely useful resource. And it breaks down the cases into the contributing factor, which led to the wrongful conviction. And there's an overlap in factors because some cases there's more than one factor involved, and therefore it's not that the numbers add up to the number of exonerations. So if we look at first and foremost at the issues, these issues are far from being unique, and most jurisdictions are affected by them. official misconduct or mistaken witnesses, eyewitnesses. You know, problems with eyewitnesses exist across the globe, but they're not particular to one area or another. Problems with forensic evidence are general, etc., etc. It is interesting if I focus just now on our particular case. One of the main factors that led to his conviction was his confession. When he stated to have been at the scene of the crime, he said with a partner, and he was involved with the burglary that led to the death of Advocate Levinson. And if we look at false confessions, according to the registry, false confessions are involved in no less than 12% of all wrongful conviction cases. And if we look at the particular instance of Mr. Shalom, I think it goes without questioning. It's very self-evident that a suspect suffering from withdrawal symptoms who's investigated over day by day, over weeks, is prone to submit a wrong false confession at some point. But it takes, modern literature shows it takes even much less than that. Leading forensic psychologists, including Saul Kassin in the United States, Alison Redlich and others, have demonstrated that it's very easy to elicit a false confession from suspects in police stations. And it's interesting to note that counter to what might be our intuition, that the higher the stakes, the lower are the chances that someone will give a false confession. He'll sort of restrain himself if the stakes are high. When we focus on homicide cases, we can see that the rate of false confession is 10% higher than the average on the previous slide we saw, and amounts to 22% of these exonerations. So in 22% of exonerations for homicide, false confessions were involved. So this is, of course, vastly important. It shows how we can learn lessons from cases of wrongful convictions, and we can come to conclusions regarding police investigations. How should confessions be evaluated in the courtroom? How should the court decide upon a request for retrial? And indeed, in Israel, since 2018, there's a public committee headed by a former Supreme Court justice, which is looking into certain known causes for wrongful convictions and examining existing rules pertaining to retrials. The committee has thus far published a report on eyewitness testimony. The report has been translated to English and is included in the volume that Barak showed you before in our joint project. It published another report on forensic evidence, and it's currently discussing the issue of false confessions. And I hope that their recommendations, based on the literature, will prevent interrogating suspects such as Mr. Shalom in the manner by which it was questioned. Let me go on to something else. We could talk in depth about causes for wrongful convictions. I wanted to highlight a particular issue that came up in Mr. Shalom's case, and I will quickly, because of lack of time, highlight several issues which pertain to barriers to exoneration. So we have the causes and we have the barriers, and also in the book, in the collection, we have a section devoted to causes for wrongful convictions and another to the barriers that exist in rectifying wrongful convictions. And once again, as I said in respect to causes, also when we look at the barriers, we see many, many commonalities around jurisdictions. This is not a particular phenomena of a certain country. It more or less exists around the globe. So if I go back to perhaps the first slide, you will see what are the barriers I at least meant to mention, and perhaps for lack of time, I won't go through the entire list. So the first is the preservation of evidence. In what cases, what types of evidence, and for how long should evidence be retained following a criminal proceeding. There's much controversy in most countries surrounding these issues because preservation of evidence casts a very heavy burden on the state and involves substantial resources. Nonetheless, it seems uncontroversial that this is an area that requires regulations and that the state's duties in this respect should be very clearly defined. It is also, I think, not open to argument that in serious cases that carry very heavy penalties, evidence should be preserved for longer periods of time. Unfortunately, in Israel, as in many other jurisdictions, the legislator and the courts have yet to confirm clear duty to retain evidence. And currently, the absence of a clear and coherent set of rules leads to very random practices and conflicting notions about what should be preserved. And that, of course, impairs the convict's rights to retrial. And why is preservation so important? The main reason is, of course, to allow later testing of the evidence to take place. And sometimes the evidence wasn't tested in real time. And in other cases, the tests, the actual tests, which are available to us today, weren't available at the time of the investigation. This was the case in Mr. Shalom's case. DNA, as we know today, was there weren't DNA kits in the possession of the police. It wasn't applied in criminal investigations, and therefore the mask left at the scene of the crime was not tested in real time. But when the petition was being worked upon, we could test. We know about the tests were available. And it was possible to test the physical evidence of the case. And if one thinks about the tremendous success of the Innocence Project, which I assume some of you might know of, a project based in New York, founded in 1992 by Barry Scheck and Peter Neufeld, their success was exactly by taking old cases, finding the evidence, and running DNA tests on the evidence and demonstrating through DNA, they only work by DNA, they managed to demonstrate by the use of DNA that 375 individuals, 21 of whom were on death row, were in fact innocent. And now this is crucially important, and if the evidence wouldn't be in existence, the tests wouldn't be available to the Innocence Project. Now, today, in most police investigations, there is DNA, but we don't know what the science of tomorrow will allow us to do. And if we don't preserve the evidence, then tomorrow, when another technique is developed or other scientific tests are available, we won't be able to do anything in order to examine the claims of innocence of convicts. Another issue I'll just mention in brief that came up in the case is how should the court treat cases where criminal enforcement authorities inflict severe evidentiary damage on the convict by losing the evidence? What should be the result of losing the mask in the Shalom case? Should the court say, I'm sorry, we lost the one piece of evidence that could have proven your innocence, go back to prison? Or should any weight be given to this fact? The court in passing has said that in some cases this might tilt the balance in favor of the petitioner, but when the arguments were held in this respect, in many cases, they never actually were left any impression on the court. How am I now for time? Okay, so I'll very quickly go over what's left. Post-conviction testing of evidence, another issue that came up in Mr. Shalom's case. Let me note two interesting points. First of all, what should be the role of victims in post-conviction cases? I mentioned the issue pertaining to the widow. Should they be allowed to take an active part in these proceedings? Is their well-being an issue that should be examined? I think if anything can be learned from this case is that generalizations regarding what victims need and want are are something that cannot be made, and that one has to think normatively about the issue of particular requests of victims. The second point is the adversarial model. Is this a model in which we should try wrongful conviction cases? The prosecution is the same prosecution which initially filed charges against the accused. And then again, when there's a question of who's being innocent, they appear in court and usually defend their case, which is natural because of the known biases. So Catherine will later on refer to models by which wrongful conviction cases should be determined, and interestingly, in adversarial cases in the countries, there's a turn to inquisitorial models in order to address to address wrongful convictions in general. I'll skip the threshold. I'll say just one word that there aren't in existence international standards regarding wrongful convictions, which in itself is quite astonishing. Very recently, there have been attempts to address this issue in a UN forum, and this is an event that took place in May, but this is the beginning of a very long route, which may bring to establishing international norms regarding wrongful convictions. Of course, if there were international norms, it would be easier to fight these causes on the national level. So let me conclude by saying that Mr. Shalom remains incarcerated as many others around the world who pay a heavy price for the current way our criminal system works. Being a human system, it is always prone to mistakes, but it is our duty, both as citizens and as academics, to call for learning the lessons that these so-called accidents teach us, both in order to avoid them in the first place and to rectify them afterwards. Thank you.
Thank you, Annette. The tech person. All right. I want to put up well, before I get started, I just want to thank Professors Ariel and Gelsler for inviting me to be a visiting professor, and Professor Eisner for welcoming me today. I did my MPhil here in the 1980s, so I sat not in this building, but in the building with the red door, which they had nicely preserved, which is it was great. And I have to say, it was probably one of the best experiences of my education life to come here. And I know you're going to have a great year. I think it's still a year, isn't it, the MPhil? Yeah. And I made friends I still have. It helped me with my career. It was wonderful. So I really congratulate you that you're all here. First day, first class was penology with Professor Bottoms, actually, which was fascinating. So anyway, good for you. So I'm thrilled to be back for that reason, and for also to get to promote our hopefully our book that will be out in, I think, January. We're hoping January, February 2023. But and my presentation dovetails nicely with Annette's, because I'm going to talk about post-conviction review. So Annette sort of led you through how wrongful convictions can happen, and I want to talk now about, well, how do we rectify them once they've been in the system and they've been through the courts. So I'm going to be doing that today. This is an abstract of my presentation, which is long and rather dull, but what I want to do is talk about miscarriages of justice very briefly and post-conviction review, and then I want to look at the system that you have here in the UK, the Criminal Conviction Review, the one we have in Canada, the Criminal Conviction Review Group, CCRG, and the one that you have, the Criminal Cases Review Commission, which is an independent body. And then what I want to do is talk about a case that we're working on in my innocence project at University of Ottawa, who sadly, like Mr. Shalom, is still in jail for a crime that we're convinced he didn't commit. Now, also to this, some of what I'm talking about today comes from a chapter that I have in our book entitled UK Criminal Cases Review Commissions and the Slow Road to Policy Transfer in Canada, which I co-wrote with a British colleague, Professor Emeritus, actually, Clive Walker, from the he's a professor emeritus of criminal justice studies at the School of Law at University of Leeds. And he's written a ton on this area. He and Keir Starmer, who's your labor leader now, right, wrote the first 2 books about wrongful conviction that really opened my eyes to the problem in the 90s, actually. So I want to talk, I think it's important to say, and that really did underscore this, is that it's no longer considered an anomaly. When I first started studying this problem about 20 years ago, it was kind of an odd thing, and people didn't believe that it happened. They had faith in the criminal justice system, that people got things right. But for me, the eye-opener for me was watching the film Hurricane. Has anyone seen that movie? It's about a boxer named Reuben Hurricane Carter. It's a true story. And he's wrongly convicted for triple homicide in New Jersey in, I think, the 60s. And it was Canadians who helped exonerate him. And they made a film out of it with Denzel Washington. And there's a scene where they're in the courtroom and he's convicted. And you just see this look on his face. Even now it gives me chills. And I know he's acting, but just that notion of being convicted for something that you didn't do and nobody believes you. And he got a triple life sentence, right? So for me, I started getting interested in looking at this phenomena, which was at that point in Canada, something that wasn't studied very much. Now, in terms of how do we rectify it, clearly most common law jurisdictions accept that it happens and they have some form of post-conviction review. Now, the model that you have here in the UK has been heralded as the leading model of administrative bodies designed to review claims of innocence because, and I think the most important part of it for me anyway, is that it's independent from government. And that's how it's always been viewed in Canada as something to aspire to. We've seen similar models follow in Norway. North Carolina is the only American state that has something similar. New Zealand, and which recently opened or began seeing cases through a similar model, with Canada and Australia considering it. And in our book, we have chapters from each of those countries talking about that. Now, in 2009, Professor Walker and I considered that notion of an independent model, post-conviction review type model for Canada, and we thought that it could work and it would be a great idea. And we still, and our chapter now in 2023, we're this many years later, still reiterating the importance of it. Now, just to briefly, and I won't take too much time, just how does it work in Canada now? Well, it's ministerial review is a means of revisiting a conviction. It's very similar to the C3 division of the Home Office, which was before your CCRC. So it's the old system that you have is the system that we have now. It's very long. It's very tough. It's the criminal code that allows the opportunity to actually do that. But the important thing to remember too, for our purposes, is it's not about innocence. And innocence, there's no designation of innocence in Canadian law. It doesn't exist. Okay, so either you're guilty or you're not. There's only two, you're acquitted or you're guilty. There's only two versions. So you don't have to be innocent per se, as it's not a prerequisite for the minister to grant a warrant, because it's the minister that decides. And I'll go through that in a sec. But the standard is the minister has to be convinced that there's a reasonable a basis to conclude that a miscarriage of justice likely occurred. Now, what does that mean? Very, very vague, right? So that's part of the problem. So how does one become eligible? Well, you have to exhaust all your avenues of appeal. In Canada, we have an appeals court in every province. You have one, I think, for criminal cases. And so you have to have your first instance conviction, and then you go to your appeals court, they dismiss it, then it has to go to the Supreme Court, they dismiss it, then you can have a conviction review. So it takes many, many, many years, right? And the only way that it will be reconsidered is if there's new and significant information. So if you have somebody if you have something that establishes or confirms an alibi, another person's confession, another person who's at the scene of the crime, DNA, the gold standard, hardly ever there. I mean, I admire the Innocence Project because they do that great work, but that's I think there's DNA present in, I don't know, less than 10% of a lot of homicide convictions. So it's not necessarily, even despite what we see on television, it's not always there. Anything that shows a witness being a false testimony or something that contradicts testimony. So it's not something that it's a very, very high standard. Now, there's only 8 lawyers that work for our CCRG, 8 lawyers. They look at a case and they make recommendations to the minister. They also have a special advisor who's Justice Fish, who actually wrote the foreword to our book, and he helps them on like controversial cases. And it can take months or years. And when I talk about Michael's case, you see how long it's actually taken. So the first step is the second step is the investigative brief. The first step is the preliminary assessment. And once you pass through the preliminary assessment and they begin to investigate your case, then share that information with the applicant and their lawyer. But the final report, where this group of lawyers makes advice to the minister about whether or not he should, it's a man now, he or she, but we have a male Minister of Justice, to make a recommendation for sending it to the Court of Appeal. There has to be, it's referred in the standard is looking at fresh evidence, as I discussed. Now, what can the minister do if he's convinced or satisfied that it is a miscarriage of justice? He can order a new trial, which is great because that really, for the wrongly convicted, the conviction goes away, and then the Attorney General of the province would have to decide, okay, we're going to revisit this particular crime, or order a new hearing for a person who's been found to be a dangerous or a long-term offender. Those are very specific designations in our courts for people who've committed usually effectively violent crimes, or refer a case to the Court of Appeal on a question, or ask the Court of Appeal to view it as if it were an appeal. Now, the possible outcomes, it goes to the Court of Appeal. There could be a trial to retry the matter afterwards. The charges could be withdrawn and no further evidence is offered, and the result is a not guilty verdict or a stay of proceedings, which puts the whole process on hold for a year, and then within that time, the Crown can bring charges again, or a new trial. As I said, that's what the wrongly convicted want, and they're treated as innocent. It's most desirable, and then the Attorney General has to make a decision to retry the matter. But because these cases take so long, 20 years, 30 years, 15 years, sometimes witnesses are dead. The evidence has disappeared, as Annette said. It's not, preservation policies differ across the whole country of Canada. So it's often the case that the matters aren't retried for those reasons. Now, what's problematic about it is that I think there's a lot of things wrong with it. It doesn't accept a lot of cases. I'll give you some stats in a couple more slides. It takes a very long time. The level of accountability is kind of not there, and it can be expensive, right? So once you have people from jail submitting applications for conviction review, and they say that they look at those ones first because they're incarcerated, but the reality is that there's only 8 people that work there. It's a very slow process. And in terms of ascertaining whether or not a miscarriage of justice occurred, the criteria are not clear. I remember at one point I spoke to one of the lawyers who's looking at one of our cases now, and I said, can you please tell me what it takes to take a case from preliminary assessment to the investigative phase? And he said, now, Catherine, that's a $64,000 question, which was really annoying and didn't tell me anything about what I don't think he knew, right? It's like a feeling, okay, yeah, I'm thinking this person may be innocent. Now, it's also considered to be an extraordinary measure, right? And to me, I don't think wrongful convictions are extraordinary anymore. I've been studying them for a long time, but maybe that's just me, but they have been. And I don't think we should be treating it as this unusual thing. And finally, our Minister of Justice is also the Attorney General. So that makes him the head prosecutor. So what we're asking essentially is we're asking somebody from the executive branch of government, the minister, to overrule the judiciary, which is connected to both. So to me, that continues to cause problems. Now, the idea of having an independent review body in Canada is not a new idea. There's been a number of high-profile cases that triggered commissions of inquiry. There were 6 in recent last 20 years for over 9 men, all men who were wrongly convicted. And each one of those commissions stressed the importance of having an independent body to review what has happened. Now, we also, the current federal liberal government of Trudeau is trying to establish the creation of an independent commission. And I was a witness at hearings in November. It's been a year now, actually, almost a year, looking at what that should look like. And so they put together a proposal, and they're waiting debate in the House on whether or not we will establish this miscarriages of justice commission. I think it's a really important step. Now, just you don't have to read all this, but I just highlighted what I think is important. In the review of David Milgaard's case, and he's one of our most infamous wrongly convicted persons. He was sentenced to life in prison at age 17 for a murder, a sexual assault he did not commit. And he was in jail for 23 years. And when he was released, he got a big whack of money, but he had a lot of difficulties. He died actually last May. But at the time of his hearing, and he didn't even want to attend this. This is many years after his wrongful conviction. He felt like he didn't want to go over it again. They were going to subpoena him to do it, and it became this big complicated thing. So he did testify, but off, sort of out of the courtroom. And one of the things the judge found in his case was that not only does the involvement of a federal politician invite public advocacy and accusations of political influence, but the process not only has to be truly independent, it has to be seen to be independent. And I think that's a really important thing. Now, it also, an independent body would have stronger statutory status, facilitate dialogue with our appeals courts. But the thing is, anything like that, like your CCRC, it needs to have greater resources attached to it. And people don't care about prisoners that much. And one thing, if I've heard it once, I've heard it a lot, is like, someone's wrongly convicted, well, they must have done something, right? So maybe not that, but I'm sure they're guilty of something else. You hear that too. Now, as I say, we only have 8 lawyers and 1 special advisor, whereas the CCRC has 12 commissioners and 90 staff, and 40 case reviewers, right, amongst that. Well, you know, we have less population, a smaller population in Canada, 38 million, compared to your 68 million on this tiny little island. It's quite interesting. You feel it some days when there's a lot of people on the street. But anyway, also we have a fairly complex system with provinces. We have common law throughout our country, but Quebec, where I live, it's also a civil law system. So there are some differences, but it is something that I think is really important. Now that CCRC, your commission, maybe I'm telling you stuff you already know, but it's independent from government. And I think it's very, that really helps its legitimacy. When it was first, and it performs very well compared to the C3 that the Home Office used to operate, which is what we have. And its decisions are not subject to ministerial approval. So remember, if there's a wrongful conviction in Canada, the minister has to have sent it to the courts, whereas your CCRC is the body that would undertake that, which wouldn't have any dog in the fight in the same way, maybe. And when it was initially set up, it dealt with a huge backlog of cases, and it is relatively successful. And it's been said to provide a more sort of rigorous investigation of claims of miscarriage of justice. Now, one main criticism that you hear quite often is that it's constrained by the Court of Appeal and it has to meet the real possibility test. So as a result, it's always second guessing, will the Court of Appeal accept this case? And there's been also, I guess, criticism that it derives people that are running it come too heavily from prosecutorial policing interests and middle-class backgrounds, which isn't really representative of the individuals who are wrongly convicted. And that it's not systematic or proactive. So it simply deals with cases, but it's collecting all this data. Like, think of that, right? Like, as researchers, what you could do with all of that data, and they don't really do they're doing a bit more now, I understand why this tells me, but they don't do that much. Now, as I said, it performs about 4 times greater than the older division. And I've kind of said that, but it also, there was a tailored review in 2019, and it basically looked at everything over a number of years. This is done by the British government, and the current delivery model was thought to be appropriate. And so it reconstituted its administrative board. There was some concerns that maybe it wouldn't remain independent, but it did, and that's been retained. Now, one of the questions I think is important to think about is that when we're talking about independence, I think it's very important that a body such as this should be independent from government, but should it be independent from courts? And the reason why I raise it here is that the Runciman Commission of 1993 that really created the CCRC, one of its recommendations was that it should be independent from courts. But that would call for a sort of constitutional change in how cases are dealt with, and maybe it's too radical for that time or for this time. But the idea is that maybe we should afford a body like this powers of bypass support to determine or settle applications, where possibly the CCRC makes recommendations to the court, and then the judge has to decide whether or not they disagree. Now, the one body that I know of that does this is the North Carolina Innocence Inquiry Commission that was set up in 2007. And it's a commission that investigates cases, and it refers them to a 3-judge panel, but it doesn't sit necessarily as a court. They don't go through, and if you read our book, you'll read a chapter about it, but they don't go through a lot of cases. It's very few cases that actually meet their very high bar. So now I want to just end with a discussion about Michael Cass's case. And I think it sort of illustrates certainly the problems with our system. He is, he's in, I don't know how old he is now. He must be 32, something around that age. And I think in his case, he sort of meets some of the barriers that Anat brought up. And in my view, there's a complete lack of credible evidence against him, despite a very lengthy investigation into his case. This gives you just an idea, maybe you can't see it. These notes will be available if anyone wants to see them, of the pretrial timeline, and I'll just take you through it a little bit here. Now, Sonia Godet was found murdered in her apartment in January 2005 in Hamilton, Ontario. She knew Michael. He sold drugs to her. He's also African-American, so he had 2 strikes against him in terms of policing. And he was interviewed and released by the police shortly after. He was interviewed a second time, also released, provided a DNA sample. And January 2006, his former partner, Megan Fitzpatrick, mother of his 2 children, was interviewed by the police 3 times. She only implicated Michael on the 3rd interview. And I'll tell you what she said in a second, because that was she was the main Crown witness and the main evidence against him. So a new case manager, though, came onto the Hamilton police, looked at the file and said, let's arrest this guy. And he was arrested for murder in April 2007. Now, the Crown evidence against Michael was a number of things. It was his DNA evidence on cigarette butts that were found in her apartment. His and her DNA evidence on the same cigarette butt. So they were sharing them, clearly. And he never said he didn't know her, that he did socialize with her. But the Crown said that they had evidence that he smoked those cigarettes between January 1st and January 5th, the time that she was murdered. Now, it's impossible to accurately pinpoint DNA in that manner, but that was one of the things that the Crown brought forward. Now, the main evidence against him was a statement that Megan Fitzpatrick made, that she said this is the 3rd time she was interviewed, and she said that Michael came home the night that Sonia was murdered. She remembered this a year and a half later, and he was covered in blood, and he washed his hands for about 15 minutes, and he had blood on his black jeans, which an expert said you can't tell that if you have blood on black jeans. But he was washing his hands for 15 minutes, and he said to her, and this is the only thing that linked Casa to the offense, was she said that he told her something bad happened to Sonia. There was also video security footage, but it was impossible to tell who. There was an African-American man in the lobby of the building on this footage, but Megan didn't identify him, and nobody else did from that video footage. Now, the defense case was weak. The counsel, I think the defense case is weak. The counsel felt that there was no real case, so they didn't mount a huge defense. Michael was convicted of second-degree murder, December 2009. He got a life sentence, which in Canada is your entire life and your parole eligibility, depending on the type of murder. First degree, it's always 25. Second degree, it can be varied. And his was 13 years. He's still in jail right now. And the appeal that happened in March 2013, though, that was based on a number of grounds. And the lawyer that got involved in this case is now a judge. And she wrote some articles about Michael. She compared him to Stephen Avery from Making of a Murder. He's Canada's Stephen Avery. And she also made a video about what had happened. But now that she's a judge, those have been taken down, so I can't share them with you. And she sought, at that point, though, Megan Fitzpatrick recanted her confession. She said that she lied at trial and she understood she was committing perjury. And she said she did it to punish him because he treated their children badly and he assaulted her. And she said that the police convinced her of his guilt. Shortly after she made that sworn statement, police start showing up at her house. Here you have letters from Michael. We have a search warrant. And they started to subtly threaten her. She said this, we know this, she told us. And she later retracted her recantation. So he had no appeal. So it was dismissed and the Supreme Court dismissed it in 2013. So we heard from Michael in the fall of 2014. He came to us and there were at least 5 students that worked on his case over 5 years. 2 of them started in the 3rd year of their BA, worked through their MAs, and they're both working in government and they're both still involved with the case. They call Michael, they know what's going on. And that's one of the strengths, I think, of an Innocence Project is the dedication of students because they work so hard. Nobody gets paid nothing, anything, and it's a really hard haul. And so we found statements regarding the blood evidence because her description of blood evidence didn't match the actual offense that took place. Sonia Godet was strangled. There was no blood. Her apartment was set on fire. So she's not only a liar, she's lying about lying, right? So what she had said is inconsistent with the evidence. We went to Hamilton on many occasions and we found several people who pointed to other suspects in that case. And we also felt as though, and there was a very small amount of blood, let me say this, that came out of her nostril, and the fireman said that probably happened when they moved her. So it wasn't there was no 15 minutes of blood on her hands. And then when Fitzpatrick found out about that, she remembered that maybe Michael came home with blood on another time. So, I mean, she's a completely discredited witness. And there was police action that we felt was, had an impact possibly on this case because of their involvement at a later time. Michael had been a police informant and then no longer was. And there was just some tunnel vision totally on the part of the police. So we submitted a factum to the CCRG in July of 2019, and it's still at the preliminary assessment stage in the fall of 2022. One of the things and they've been able to get more evidence than we have. They got the full police file, full Crown file, and they're looking at possibly ineffective assistance of counsel at the trial level. So we're exploring that a little bit. But I just want to say, okay, there's like a couple more slides. How would the CCRC, how would your CCRC have dealt with Michael? Well, from what I know, it doesn't refer to cases because they're based on purely circumstantial evidence, which is kind of what Michael's case was. And they show deference to jury verdicts, and they don't examine ineffective assistance of counsel cases, which is what we may be going for. Sorry, I got a typo there, but it excludes lines of inquiry that are related to something that's already been fully explored. And I think they may have probably rejected Michael's case, but they probably would have done it a lot sooner than our CCRG is doing it. I think, though, that just to look at stats to give you an idea, the independent model, we're still hopeful, but we're still hopeful. We're dealing with the CCRG, and we're really hoping that something's going to turn up amongst all the evidence that will point to a referral. So if you just to give you an idea, over a very long period of time from the beginning, there have been over 28,000 applications to your CCRC, a referral rate of about 3%. And of those that are referred, 70% success rate. And I don't have long-term stats because the CCRG doesn't keep them. We compile them ourselves. And over a 13-year period of 272 applications, 16 cases were referred to the Court of Appeal, 13 overturned by the courts. So I do think that our model is, the CCRC model, separate from that direct ministerial and administration and final decision-making would be better for Canada as a more effective mechanism for review and even symbolically, right? And I think because of its more independent, its true independence, it would probably overturn more cases. And that is one of the main recommendations of the current Liberal government around their miscarriages of justice commission. So thank you very much. And
Evening Grounds, are you available? I am.
Hello.
Hi.
Second. Better find you where you are.
Yes. Can you see and hear me?
Not yet. Oh, now we can see you. Yes.
Can you hear me?
Yes.
Great. Thank you both to Anat and Catherine for very, very moving and erudite contributions. I'm glad you focused on two cases that illustrate the terrible long-term predicament of people who claim wrongful conviction for often throughout their lifetimes. Just three specific points. Anat asked whether the issues she described are specific to Israel. I think the answer is emphatically no. There were many features of Mr. Shalom's case and some of the other matters she raised that are very reminiscent of issues we faced here. For example, the pressures we see on police in notorious cases to apprehend suspects quickly, the hugely substantial hurdles to get cases reviewed, and the risks of self-incrimination in states of drug withdrawal. We've had very similar cases here. And the important point about the position of the primary crime victims, when often years later, doubt is cast on a conviction or a conviction is quashed, the position of the primary crime victims is a very distressing one. They may be re-traumatized. There's confirmation that the proper offender has not been brought to justice, has gone free. They haven't seen justice either. So their strength of feeling in these circumstances is important. And with regard to what Catherine said, just two quick points. The independence of the CCRC, yes, I think you're absolutely right about its formal independence. And one of its great values is it has very substantial statutory powers to investigate, including to order or direct police to look for the police to carry out investigations and to require evidence from public bodies and so on. But what government can do is contribute to other substantial constraints on the CCRC, particularly to do with resources and finances. And our CCRC has seen substantial pressure on its resources, substantial reductions in real terms over the years, in real terms of its resources. And of course, what that causes, a number of people comment on this, is a tension between the pressure to process cases quickly versus to investigate cases thoroughly, which is expensive. And there is, some people think the CCRC has become much more cautious and limited in the degree to which it thoroughly investigates cases that where there's a clear need to do so. The chair of the CCRC is part-time, funded for 10 days a month, and the individual commissioners are now part-time, appointed on an expectation they work 1 day a week, and the commission has lost its base. So those resource constraints are really important. And the last point, it's nice and of course flattering for you to look across at the UK and see the CCRC as a good example. I'd just like to reverse the spotlight actually and ask you this, that in Canada, one of the things that always looks to me impressive from this side of the Atlantic is your tradition of holding independent judicial inquiries in individual cases to investigate where things have gone wrong. For example, in the Sofano case, a retired Supreme Court Justice carrying out a very extensive inquiry in an individual case. Very difficult to see judiciary of a similar status carrying out similar inquiries into individual cases here, I think. And I wonder what it is about Canada that that enables this to happen, and what it indicates about how seriously miscarriages of justice are taken. Thank you.